சாக்ஷி ஒண்ணும் இல்ல. இதுல இந்த இது இருக்கும்ல, அத மட்டும் ஆஃப் பண்றது எப்புட்றா? நம்மளுடைய கேமரா ஆல்வேஸ் பிளாக் கேமரா அண்ட் மைக்ரோஃபோன் அக்சஸ்ன்னு வருது.
Welcome to day 6 of 7-day national level interdisciplinary virtual faculty development program on empowering teaching and research through emerging technology. I would like to call upon Ms. Kritika of 2nd MSc Physics to introduce our speaker.
Good evening, all. I am profoundly delighted to introduce Dr. B. Anbarasu, who is currently the Associate Professor and Head of the Department of Physics, Self-Finance at PSG College of Arts and Science. Dr. B. Anbarasu completed its Bachelor's and MPhil in Physics from Erode Arts College, Erode, and his Master's from St. Joseph's College, Tiruchirappalli, and his PhD from Anna University, Chennai, specializing in material science. Dr. Anbarasu has over 18 years of teaching experience and has served as a lecturer at Erode Arts College, Vivekananda College of Arts and Science for Women, and SRM Institute of Science and Technology, Ramapuram. He has successfully guided 73 bachelor's and master's students through their project work. Recognized as a research supervisor, he has also guided research scholars at SRM Institute of Science and Technology, Katangulathur, in the field of physics and material science. Beyond his roles as a lecturer and research supervisor, Dr. Anbarasu has delivered numerous invited talks and guest lectures. He has actively participated in many workshops, seminars, and conferences at the state, regional, national, and international levels, sharing his knowledge and expertise. He has also organized several seminars and conferences at the institutions where he was working. Dr. Anbarasu has published 30 research papers in reputed international journals and is an expert in handling equipment such as XRD, thin film coating units, and UV spectrometers, among others. He has received awards for his outstanding academic performance during his graduation and for academic research excellence throughout his teaching career. On behalf of everyone present here, I would like to thank Dr. Anbarasu for accepting our invitation to deliver a guest talk. I now request our esteemed guest speaker to share his insights with us. Thank you, sir.
Very good evening. Thank you for your great introduction. I think I'm audible. Is it?
Yes, sir, you're
Yes, sir.
audible, sir.
Yeah. Okay. So I just want to share my slides. So is my screen is visible now?
Yes, sir.
Okay, one second. Okay. So I would like to thank the organizers for giving me an opportunity to discuss about IPR, intellectually property rights, and proposal writing for funding agencies in the 7 days national level FDP program, virtual FDP on faculty development program. So for that, I would like to thank the organizers of giving me this opportunity. So now I just want to discuss about two topics because I given our. So I just want to separate two topics of half an hour each. The first topic is intellectual property rights, and the second topic what is proposal writing for funding agencies. So there are two separate topics. I just want to conclude within 1 hour of time. Right. So, regarding the concept of intellectual property rights, it's one of the most intriguing topic in the current field. Wherever we go, we're normally thinking about the case of especially regarding educational institutions. We mostly working with the case of not even simply doing a project work. Everybody want to make it as a product. So whenever we want to make a product, we must be patented properly. Why? Because of that is our real innovative work that to be recognized or to be accredited. So only for that reason, we are mostly focused towards intellectual IPR rights. Okay. So on this today's presentation, just I want to give the frameworks like this: so introduction to IPR, and then types or categories of IPR in India, legal framework of IPR, and then recent developments initiatives, and what are the challenges and opportunities regarding IPR. Right. So what is the real definition of IPR? So we already know well, it's legal protections granted to creators for their inventions, literary and artistic works, designs, symbols, names, and images used in commerce. So this is the exact definition what is called IPR. So these rights enable creators to control the use of their creations and benefit financially from them. That's very important because we are going for patent. We must need up some financial benefits. So only for that reason we go for patenting. And then regarding the importance, we already known well, it is very crucial for fostering the innovation, creativity, and economic growth. So we already known well, India is a leading patent filing. Leading while comparing with China and other countries. Why? Because of government is taking initiatives by means each and every product to be designed based on innovation. So it encourages the investors and artists to create new products and works by ensuring they can reap the benefits of their efforts. We normally believe that we see called as normally the idea of innovation is most important because the requirement is the mother of all innovation. So what we require that will be automated or to be used with certain process. So that process to be patented by means whenever we make it as a device or a product, so that will be gives you our financial benefits. And regarding the categories of intellectual property rights, as per India, we have these 7 categories. One is a patent, trademark, copyrights, plant breeders' rights, and then design, geographical design, industrial design, geographical indications, and trade secrets. These are the 7 categories of IPRs what we are supporting in India as of now. So these are the 7 are to be termed as intellectual property right categories. So now we go one by one. So we already known well regarding what is called patent. So a patent is an exclusive right granted for an invention which provides a new way of doing something or offer a new technical solution to a problem. So this is called the explanation or called a definition of a patent. So regarding as per India, we have 20 years of validity from the date of filing. So we are given with a patent rights for a lifetime of 20 years, and then we have to go for renewal of it. Okay, so this is the patent. And then I just show you one picture of a patent regarding Vision Research Foundation patentee and the concept of a semi-nested polystyrene chain reaction PCR method for rapid detection and specific identification of Mycobacterium thieleum. So this is the patent is awarded. Actually, whenever you go for applying for a patent, so we have certain processes. The first one is scrutiny, and then we just see about publishing of the patent, and we have to wait for our turn to verification. After that, if there is any claims, then that claims to be settled, and then finally the patent to be awarded on our name. So those are the appliers. So they will get the called as creators. We got the publishing of, acceptance or awarding of the patent. So actually in the latest days, you just notice that one is a very famous case regarding the importance of patent. Actually, till that, people are never known very clear. So we have one very best example regarding the difference between innovation and public health. This because this case is gone till Supreme Court to get a judgment for around 10 years between a private foreign-based company, medical company called Novartis, versus their claim of Gleevec. That is a medicine what they given for anti-cancer drug. So actually in foreign, I say about in USA, the cost of one fuel is it's around $2,500 US, whereas like India, we already known well, the people are never affordable to that much of amount. So what they have done is they started creating generic volumes. I think all of you know what is called generic volumes. It's a very special case. If you want to go with a paracetamol or a Calpol, or you go with Dolo 650, we have paracetamol is the generic volume. So every companies may have a smaller option because you know well, we are very known with Dolo 650, Calpol 650. So we are going to purchase in a medical company or medical distributors with a name. So for that, they are paying so much of money on advertisement. Whereas some companies are working to produce the generic volume with very minimal changes in the composition of the chemical. As a physicist, we already known well how to prepare the composition. It's smaller, minute are called as mere changes. So that is called, normally called as generic volume. So like that, they prepared a generic volume for about $175, around 8,000 rupees, whereas it is in around 2 to 3 lakh rupees in USA, whereas in India it is to be around 8,000 to 9,000 rupees. So that case gone to by filing of patent, and then you just see it just started in the year of 2003. So now what is launched as imtamate mesylate is a chemical name of Gleevec. So against blood cancer medicine. So in USA it was sold as $2,600, and in India it is to be sold at a cost of around $200 only per patient per month. So by this case, after the called as a Indian International Agreement, TRIPS agreement. So now what is filed a case against the use of generic medicine in India of the same composition, and then finally it came to the solution that now what is loses the gate because of there is a final argument in Supreme Court says that they are never failed with the efficiency. They never mentioned about the efficiency of the particular medicine, because we already known that whenever you go for public health, we must be very careful regarding efficiency. Only on that case, they failed to reply the patent. So it is a very big issue actually in USA-based company. They say about court denies Swiss drug firm patent protection for its anti-drug Gleevec, domestic industry hails with it. Like that, the title is given on the immediate next day, because 1st April 2013, the results were declared. And then we just see here. So we just see here on the immediate next day, there's a large decrease in the GDX values because of in the called as in the pharma company, there is a losing of the rights. After the immediate next day, their share decreasing. It just is about 1.8% loss. It's because of they want to maintain the drug to be sold in India with the same price as in USA, but that was dropped. So that is a very big issue regarding the patent and its files. And then why? That's why we say we are very much important regarding who is the real owner or who is the real creator of the particular invention. So that's why we are going with filing of patent. And then what is the requirement of a patent? So what can be patented? You just see we have to have 3 cases, 3 conditions. One is the novelty. We must the invention not known to public prior or to claim by inventor, and then non-obviousness. So invention would not be obvious to a person with ordinary skill in the art. And the third one is it must have industrial applications. So once you have an idea with the concept to be related with utility, then we can apply for the patent. So inventions can be made or used in any useful practical activity as distinct from purely intellectual or aesthetic one. You don't simply mention the concept of this is enough or this is the way I'm going to apply like that. You should not say like that. We must give a solution, it to be taken into industrial applications. So concept is to be taken like that, definitely they will consider for patenting. And then what is the case with the grant of patents? So we already known well in India we have 4 offices for patent is there. One is we are very close with Chennai also. So patents are granted by national patent offices after publication, because we already known well whenever you are submitting a document, that document will be given with a serial number or a file number that to be first published. So then we have to go for interviewing. So any claims or any objections to be taken on the particular recommended publications, then only to be considered the next level. Otherwise, they will go for scrutinizing the patent after some duration of time, and then finally it will be awarded. So in India, provisions exist for pre-grant or even post-grant opposition by the others. So don't think about once we got patent, everything we got. Definitely not. Even after getting a patent, if any person came with oppositions, definitely that to be considered in India. So they are valid within the territorial limits of the country. That's very important. Then foreigners also can apply for the patent. So in India, so much of foreign companies also applying for patent, because in India they need a patent rights to do their works, the industry to be run with a particular formula of the medicine or something else. So they have to apply for Indian patent also. Not even the international patent, they have to apply for Indian patent also. And then, as we already known well, what are the inventions to be patented, and then now we have to go with what are not to be patented. So any invention which is frivolous or which claims anything abusively contrary to the well-established natural laws or natural phenomena that never to be patented. So as we already known well, the maximum efficiency of an engine will be 100%. So if we want to claim, I have a patent, I have an invention, I have an engine that have efficiency more than 100%. So that cannot be patented. Like this perpetual motion machine. Very simply, you are just having an analogy of this is the real work function. We have only analogy, not a demo version, or we say, but we couldn't make a design version of a concept. Definitely that won't be patented. Likewise, well-known laws, like if you want to change Newton's law of gravitation, definitely they won't consider for patenting. So, and then, yeah, machine whose primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes a serious prejudice to human, animal, or plant life or health to the environment, that could not be patented. So, for example, you just see gambling machine, Terminator gene technology, biological warfare materials or devices, embryonic stem cells. So we already known where we have a concept of cloning. So the company, those have a concept of cloning, they tried to patent it by international, but that was not patented. We already know well, it's only because of this condition. So whenever we have called as a creative idea or invention that should not affect the human life, or it never cause any disorders to the public system. So only on that case we got patented. Otherwise, our concept or idea or product never to be get patented. Likewise, if we have a chance of mere discovery, as we already known well, very simple case, I have a proper device, already it is in the use. Suppose you want to make a very small change in the particular device, you say that I have modified this one like that. So if it is a very small or very mere discovery of scientific principles or formulation of an abstract theory or discovery of any living things or non-living substances occurring in nature, so that never to be patented. So I just given some ideas about what are the living and non-living things are available, and then at the same time we can have a chance to get patent for apparatus or method for technological applications that to be considered for an improvement in a version of the earlier here. So as of now, if suppose I'm just saying a very simple case, if I have a small meter like screw gauge or vernier calipers, I want to measure the length or breadth of the scale. Suppose I have one more new device which have good accuracy than screw gauge and vernier calipers, and that may be considered. It not by means the same device with a smaller change in the scale values, the efficiency means that can't be done by using of patenting. Okay, so these are the 5 major steps involved in patenting. As we already known well, we have to first go and search in the patent pages, is the idea or invention is already published or awarded. So that is a very first important step involved in patent filing. Okay, so the first one is filling of patent search. Once you got there is no more relevant invention is already registered, then you can go for filing of a patent application. Once the patent document is to be filed, and within 15 days to 21 days, definitely your paper, by means that particular content will be published in the is called as a IPR journal. Okay, it be from Indian Journal of IPR, Intellectual Property Rights. So we have every month there is a circulation is there. So with the file number, our patent is to be published first, and then it will go for objections and examinations under the continual process. Once there is no mere objections, and if they found everything fine with the documentations along with the process of invention and everything is suitable for awarding, and then you can get the final grant of patent. So these are the steps involved in the very first category of IPR. It is called patent. Okay. And then the next one is trademark. So as I already told you that there are 7 categories. The second one is trademark. So what is called a trademark means is a sign capable of distinguishing a good, a goods or services or one enterprises from those from other enterprises. So we already known well. So there are 2 famous beverages, cool drink beverages are there. We call as one is Pepsi and one is Coca-Cola. So those are to be have different names, different trademarks. So those are registered on their own. So we may not use those names again. So if you have a company, if we want to prepare or manufacture cold drinks, if we want to apply a name of PepsiCo or Pepsi, Coca-Cola like that, definitely they won't accept. So likewise, that is called trademark registered. So on the left side, you can have 3 different cases. The first one is R with a circular symbol. It is called, it is a registered trademark. Whereas we have another time TM. So after the name at the suffix on the top of the symbol, it is mentioned as TM. It is means trademark, used with trademark but not yet registered. So they have applied for trademark but not yet registered. Whereas in some cases we are getting not in India, whereas in foreign countries they can use another term SN. It is used only in service markets because we have so much of like names are there. So in a particular service, as I'm saying an example, Shakti is a name of a common term. We can use it as a Shakti Masala, Shakti range of products. So likewise, the same name with different services we can register. So that is called SN. So only on service marks, with respect to the particular service, you have to use the common name. So whereas if we go for it's like Achi Masala, we cannot change the name as Shakti Masala one more time, or otherwise we cannot take the, by means both are masala products. I may not use those 2 names because it's already registered. Okay. So trademarks are registered by national trademark registries and are valid in that particular country. And registration is made even after examination and also the same procedure like patenting and obligations. So regarding trademarks, what are to be taken as a trademark? We just see here sign, words, letters, numbers, drawing, pictures, any emblems, colors or combination of colors. That's very important. Shapes of goods, graphic representation of packing or any combination above. So it purely represents a company and its product. So that's why anything else you can make as trademark registered. Likewise, you just see here in service marks including in a banking, education sector, finance, insurance, we are having up some concepts regarding trademarks and regarding certification of trademarks. We just already known well AGMAR. In India, we have one company named as AGMAR that is having a concept of to evaluate the quality of the particular product. So that's called, we have AGMAR. Likewise, so we have a specific trademarks to be used as a verification of a product. So that is called certification trademarks. So certification marks cannot be used as a trademark definitely because that is given by a particular government agency called the Government of India. So likewise in Walmart in America, they are just using the particular term. So we cannot use the same service mark or certification mark for our use. So that is a globally accepted one. And then regarding, I just shown some trademarks. What are the, I think all of you seen it and you can easily understand what is the brand it is. Especially because these type of trademarks are well known to our regular life. So a trademark in general refers to a mark that distinguishes one enterprise from the other. And especially in section 2 of the Trademark Act 1999 defines the trademark a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of other person. So this is the meaning of what is called trademark. This is the another type of IPR. So regarding steps involved in trademark registration, near same as like patent, we have to go for trademark classification first. So you have to finalize what type of classification we are going. Either only with registering of document, trademark only, or SM, or you go with regular registration. So that is trademark classification very important, and then trademark to be searched. For that, any equivalents or the near sames are available. If we have a near name, near equivalent names, they won't give trademark. Likewise, trademark application to be filed and to be fees to be properly paid. And then we go for examination of the trademark. And then if there is any, they are waiting for objections that to be published after the examination. Our trademark will be published as like IPR, as like patents. And then if there is no objection, we can go with acceptance of the trademark. And then just keep it in mind, it will be around 10 years of times. I forgot to mention it's 10 years. Okay, the duration is 10 years and we can renew it indefinitely. How much time we want to renew, we can renew it. But the trademark validity is only 10 years. Whereas you go for patent, it is 20 years. And then regarding the third option in IPR, it is called copyright and related rights. So what is called copyright? It's of original literary, dramatic, musical or artist works can be registered under copyrights. So works, ideas expressed in material form, we can use of as copyright. Especially if we are as a faculty, we can write one concept regarding, actually we are using our own words on preparing of a class notes, even that class notes also to be registered under copyrights. Why I am saying this one is because we people, we already think about something else other outside, but definitely not. Even our own handwritten notes on our own words, if you write anything, there is no copyright in ideas or facts. So if we are making our own words, definitely that to be taken as a copyright. Likewise, cinematograph films are copyrighted and sound recording is also copyrighted. So regarding the duration, so literary, dramatic, musical and artist work will be have a lifetime of, life means 60 years. Whereas all other works, 60 years from the date of publication. So every 60 years, they have to go for renewal. Okay. So this regarding copyrights. Okay. And who are the ownership of rights? That's very important because in latest, I think all of you know about there is a music composer called Ilayaraja in Tamil Nadu. So there is always issues going on regarding who is the real owner of that particular song. Is the music composed by the composer or the song written by that the particular lines written by the called as lyricist, or otherwise is those are paid with the producers, or who is the real owner. So as of copyrights related rights, you just notice here for literary, any write-ups, author is the owner. Whereas you go for any drama, dramatist is the owner. Likewise, if you go for music, the composer, music composer is the real owner. Whereas you go for artistic work, you already known well, it is an artist. He may be a painter, a sculptor, architect, whatsoever. Likewise, for any photographs, that photographer is the owner. Likewise, if you go for an author of a computer program, that person who causes the work to be created. So that means who is our team leader, he is the real owner. Suppose a company want to make a program, means those are the real owners. So they are paying money by means those person causes the work to be created, he is the owner. So likewise, cinematography, producer is the owner, and sound recording. Suppose you go for sound recording, the who is the producer of the sound recording is a real owner. So in this case only, Ilayaraja's case is still going on regarding who is the real owner of the song. So till today, he is having of copyrights of all the songs what he composed, because on the category of composing only he is having copyrights. Okay. And then regarding rights, so we have two types of rights are there. As I already told you that copyright and related rights. And regarding the rights, we have two options. One is moral right and another one is economic rights. So what is called the moral rights? To protect personality of author. So right of authorship. Right. So these are the two types of rights. So one is digital manipulation is not to be done and no right for display. So unless otherwise we are getting of a proper rights from the particular author, we should not go for digital manipulation. If I'm saying an example, I'm having a hard copy of the book, suppose I have to take a Xerox copy of it, or if you make up scanned copy and I'm using it. So that is digital manipulation that we should not do without a prior permission from the particular publisher, or otherwise the publisher may got the rights from the author. So author is the real owner of the book. If a book author is writing a book, that time the publisher will get the copyright claim from him regarding that they are publishing it. So on that case, digital manipulation is not allowed. Likewise, no rights for display. Unless otherwise we are getting rights, we should not touch it. Likewise, inalienable rights are not to be done. And regarding economic rights, we have all these three options. So the three pillars of economic rights are: one is reproduction right and right for distribution, and third one is right to rental and lending. So these are the three major type of rights you can get from IPR, under IPR. So we have to, if you suppose the case, I'm applying of a patent and just getting a chance of economical benefits or financial benefits, so I may go with right of reproduction. I can apply for right of reproduction. So making copies, edition of a novel, as like we already known well, let us, we have so much of issues regarding with foreign novels. Okay, so making of copies, actually we already known well. Every time there is a film is going on, I think in latest days there is a controversy regarding this is the story of mine. I already registered the particular story. It's called edition of a novel in the IPR. So everybody want to make their own copies that to be patented by means that they make it as under copyright. So by means that any person using of the copyright, any use of the particular content, then it may be against the law of copyright. So storage in computer memory is our right production. So right of distribution means already known well. Digital distribution is possible with respect to the requirements. I think all of you known well. We are just having, if you want to download a paper, what we are normally doing manuscript, we are getting it from Science Direct. So they have, I think whenever we are submitting a paper, at the end, once it is accepted, we are giving all the authorship to the particular sciencedirect.com. Only because of that reason, they are just selling the particular paper, because they are just doing all the work of reproduction. So right for communication with public also, public performance and internet communications also under the related rights. So those are called economic rights. Okay. And then the fourth type of category is plant breeders' right. So it is a very latest question. Around 2000 it is started. Actually, there is an issue regarding in foreign countries, they just started getting approval or IPR patents regarding with the copyright regarding the called as plants, some breeds which is very specific with Indian countries. Especially, I think all of you known about the case of the neem tree. So it was get patented in America. So Nammalwar and other people are went to America to fight against the, it's called a law fight. So it is happened in around 2000. It's then after government taken initiatives by mean they start giving rights to a specific records. And so breeders' rights will be, breeders will have exclusive rights to produce, sell, market, distribute, import or export the protected variety. So once plants are getting into the rights, and that will be, breeders can appoint agent, licensee and may exercise for civil remedy in case of infringement of rights. So they have individual rights. So those are the breeders. Especially you just see in our Congo side, we have a Ghanaian buffalo is there. So we have a Ghanaian collie is there. So we have a breeders. That's are very close to the breeders. So only few people have the rights to breed it. Whereas if you go for others, then it will be, in the case of infringement, will be taken up. So likewise, researchers' rights means, so researchers can use any of the registered variety under the act of conducting experiment or research. So we also having some rights, because whenever you start doing up some experiments, that will be very specific on us. So we can go for our own rights on planted rights, and then especially those who are working on biotechnology, they have to apply and get these much of rights. And if you go with the third option, farmers' right. So these three are the very specific case regarding plant breeders' right. So just see, a farmer who has evolved or developed any new variety is entitled for registration and production in like manner as a breeder of variety. So as like what we are doing in our research, suppose we are preparing a new type of compounds and we are trying to submit in a paper. If any person following the same composition and doing up same work, that we taken as errata. Likewise, if you go with the farmers, we have this benefit. So farmers' variety can also be registered as an extant variety, and a farmer can save, use, show, reshow, exchange or share or sell his farm produce, including seed of variety protected. So all these are done by using of these plant breeders' right. So this is a very famous case again with a multinational company called PepsiCo. So they given a rights. So it is not for chip, battle for chips in Sulwanga. So it's a battle for chips, not for microchips, but potato chips. So yeah, PepsiCo is already known well, is the best beverage company in India, one of the most selling beverages, soft drinks in India. So they have a good amount of snacks, beverages, and then bottling of 4 farmers. They just raised a case against 4 farmers in Sabarkanda in North Gujarat, allegedly growing. The famous name is FL2027 variety of potatoes because they are using it for preparation of lace. So, without their permission, they breeded the potato. That is the allegement they given. So, PepsiCo company launched a complaint in a court regarding that. They the 4 farmers, without getting the prior permission, they breeded the potatoes and they asked the compensation of 0.5 from each farmers. Just imagine what is the power of a breeder's right. So after that, government involved in it, and they just noticed that in the court, in front of the court, it is taken decision that the particular farmers are doing of the business, that particular breeding of the particular potato for more than 40 years. So only on that case, PepsiCo came to the picture only by 1990s. So only on that grievances, all the 4 farmers are released from the case. Otherwise, they had to pay the compensation because that PepsiCo is holding the rights of growing FL2027 variety potatoes because it's like a sweet potato. It's a very specific breeding. Okay, so likewise, this is the importance of plant breeding. And we go with the 5th option regarding the categories of IPRs. It is design pattern. We already known well. Designs means features of shape, configuration pattern, ornament, or composition of lines or colors. This is applied to any article, whether in 2-dimensional or 3-dimensional or in both forms. By any industrial process or means, whether it's a manual or mechanical or chemical or separate or combined, which in the finished article appeal to and are judged solely by the eye. So that is the real reason whenever you go for any jewelries or any specific shops, you can see the picture of that photography is not allowed. Especially if you go for any silk sarees, definitely they have this picture regarding that you should not take photograph. Why it is? Because once you take a photograph, then you can go for designing it again back. So it's like alike model should not be provided. So like that, they are just making it under design pattern. So just see here what are the different consumer products that we already have design pattern. So each and every product is properly registered under design pattern. So once we have a design pattern, that may not be replicated by any other countries in this world, especially. Likewise, you just see here pharmaceutical products. Every products are to be get patented, design patented. Then only we can make use of it. Especially you go for syringes, syringe bottles are very specific regarding the design patterns. If we go for textile industries, so these are the varieties. I think well, textiles and jewelry. We are having very specific collection. Just go and check with any advertisement. They are clearly mentioning. So far in our shop, we have a very unique collection. So why they are mentioning the word unique collection means because they should not replicate with any other brand or any other model with any other companies, those already registered on it. So if they are selling the near same or the same model, it is available or registered by one other company means they have to pay the compensation. So that's the reason they are very clearly mentioning that they are very unique. They are a collective, like that they mention. Okay, so this is the importance of design pattern. So what are the rights of the registered proprietor? We already know the proprietor of the registered design has exclusive right to apply the design to any article in the class in which the design is registered. So basically it is for 10 years of time and it can be extendable to 5 more times. So this is only valid for 10 years and it may be extended to expandable to 5 years, then we can reapply again. So what cannot be registered or designed under design pattern means trademark, property mark, artistic work. That cannot be done under design. Any registrables, buildings and construction or real estate map flags, emblems of any country, layout design, mere workshop alteration, mere change in size, on any principle or mode of construction of articles. So that are never to be design patented. Okay. And most important, another one is, it's also a good initiative of from the government of India side. So we have so much of GA marks are there. Geographical indication goods are available. So it is an indication which identifies goods as agricultural goods, natural goods, or manufactured goods as originating or manufactured in the territory of the country or a region or locality in that territory where a given quality, reputation, or other characteristics of such goods is essentially attributable to its geographical origin. So I think all of you seen one table regarding those are the GAs. Though I'm just giving very small number, whereas on the left side you can notice from in Tamil Nadu we can Kanjivaram silk, likewise Kodaikanal Malaipundu, Palani Panjamardam. Likewise, if you go with Tirupati, it is Tirupati Laddu. So everything is came under GA tax. It means that we may not replicate again any other company in this world that should not replicate the same thing. So Mysore silk in Karnataka and all over India, they have a very specific case. Even we have a turmeric from Europe is registered under GI. So likewise, I think they plan with specific materials from particular territory of India. Especially, they have to make a GA tagging. So once you make GA tagging, so definitely nobody will replicate it. Otherwise, without prior approval, they can't even breed it also. So that is the importance of GA tagging. So GA tagging is geographical indications to be registered under the registry examines and publishes the application before registration. So keep it in. Its registration is valid only for 10 years, but can be renewed indefinitely. How much time if you want to renew, you can renew it. So likewise, the exclusive rights to use geographical indications on the goods and to be required, and right to obtain relief from infringement of the geographical indication. If suppose, I'm saying an example, if suppose a brand is to be replicated with any other companies or in any other countries, then infringement means the compensation to be given to the particular GA located area. So that is a permission given to GA rights. And the seventh important one is, if suppose I have an invention, some data that cannot be protected by any of the available means of IPR. By means, it may not be taken into the account of patent rights, because patent means you must show that what is what, how it is possible like that. So you have to be clear cut regarding the data. So patent, you can't do it. Otherwise, copyright, I cannot make it, because copyright also I need a proper reason how it is using. Likewise, I just discussed about all the 6 in the earlier. If suppose I have a component that cannot be linked with any of the 6, I have an option to go with trade secrets. So that to be protected by any of the available means of IPR. So such information is held confidential as a trade secret. So a day before yesterday, I just went for a hotel. So in that hotel, it is based on Kongu Kushain, so near to me. So they given a recipe. They in that recipe book, they given one page. So regarding their specific uniqueness, they mentioned more than 25 secret recipes. They mentioned as more than 25 numbers of secret recipes they are following. So why it is? Because of, I think already known well, in Chennai we have one issues regarding the use of the flavor of a biryani. I think Talapakati biryani, I think you know well. So all the people, those are the lovers of biryani, they know very well. So they got the trade secret of Dindikal Talapakati biryani. So why I'm saying this one is, if suppose I have a data information that cannot be protected by any other means, then I can apply for trade secret. So it may be an invention, idea, survey method, manufacturing processes, experiment results, chemical formula, recipe, financial strategies, client databases. Whatsoever, I can just store this as a trade secret that may not be done with any other IPR means. So this is also one rights we are getting. So when trade secrets are preferred, when invention is not patentable, and you already known well, if you go for patenting, it may go to the limit of only 20 years. So if you want to go beyond that, then you can apply with trade secret. So when cost of patent production is prohibitive, we already known well, the maintaining of patent also very important. It's also costly. So it is reverse. Suppose I have a difficult to reverse engineering. By means I have a recipe If I do it, I can get the product. If suppose it is given with some other person that cannot be done means that is not to be came under patent. So by means that I can make it as a top secret. So one of the very famous top secret is Coca-Cola. I think all of you know well. It's a very best example to examine because in 1886 itself, the Coca-Cola was invented. So we have Coca-Cola is only registered under by a trademark for the name of Coca-Cola, and it is industrial design. For the very special design of Coca-Cola bottle, it is a shape of a woman wearing a long skin tight dress. So that is the famous. And then we already known well till today only 2 people known the secret of what is mixed in the water. It's the purest water mixed with a powder. So as of now, only 2 people known. You just see they never allowed to travel even together. By means they never die at the same time by accident. So it is kept secret. Just imagine after 1886, around 150 years gone. But till today, the very famous competitor of Coca-Cola is PepsiCo. They never reveal what is the real composition. So now we have so much of facilities are available regarding the analysis of what are the chemicals there, how it is working. Everything we can analyze by FTIR, UV, PL, whatsoever you can take. They never resemble or never identify what are the exact composition. So that is the importance of trade secrets. So till today, I think all of those are drinking of a habit of Coca-Cola and Pepsi. You can easily find a difference. We have a difference of Coca-Cola, whereas difference in Pepsi. But we just see both are the competitors near same product. One side they're producing Fanta means here it is Miranda. They're producing Bisleri. So they're like where the Pepsi. Here it is Aquafina. So every product is near same, but they have difference of taste. That's why till today there are the lovers of individual products. It's purely based. It is listed under trade secrets. So even the strategy of the Coca-Cola also registered under trademark. Keep it in mind. So key component of marketing strategy also they are playing very well. So smart promotion strategies, sponsorships, social media, personalization, and competing with the prices portfolio. Just keep it in mind. How many of you notice? I don't know that. If you just go and purchase one cool drink, as Coca-Cola or Pepsi, both are same. But even the equivalent brands also like Fanta and Miranda, everything is same. So why it is because they are making of competing the prices. They never say 1 rupee higher, 1 rupee lower. And likewise branding, how they are making branding, that's very important. They just put branding ambassadors. It's a very big shots like very big players of cricket or somebody very big stars of film. So that is branding. And then very important global advertising. So these are the marketing strategies of Coca-Cola. So we just see the right hand side. What are the real strategies they just play? So once they start with the Coca-Cola World Cup, so by means that they developed a lot. So that's the importance of the trade secrets. So that is also under trade secrets we are coming. And regarding the legal framework, I just already told you that in India we have so much of acts are applied for development of or maintaining of increasing the count of patents. So by 1970s onwards till 2016, there is keep on increasing or there is an improvement in IPR policies, especially regarding enforcement of mechanism. What we are normally doing is in India, civil and criminal remedies. So includes injustifications, injunctions, damages, and criminal penalties for infringement. So we are imposing law. Likewise, intellectual property appellate board is available. If suppose any clearance, or if you have any any appeal, you can get clear from the particular authority before you are going for court for the justification. So these are the legal framework of IPR. So once we got patent, that never to be infringed. And regarding what are the challenges, we already known well. Wherever you go for, there are some challenges. So the first one is counterfeiting and piracy. So we already known well issues with imitation of products and unauthorized reproductions are definitely there. And then patent tickets means overlapping of patents that complicate the invention. So we already known well. Some people, whenever we develop one product, so the opposite team will produce near alike or near. That's why they say it is called near equivalent. So near equivalent product to be developed. So by means you have to come across all these hurdles. And what are the challenges means you already known well. Regarding the developments in India by 2016 onwards, it become online. IPR submission and processing are everything in online by means that it is streamlined to promote the awareness. and we already known well everywhere we are developing with the startups. So in India, we have started hackathons are there, by means government supporting a lot to increase more number of patents. That's why I think all of you known well, in NAC, actually we go for any NAC recognition, we have to go with, importantly, the marks mostly given for patent filing, publishing and acceptance, by means award. So why it is? Because government is more specific on increasing the count of number of innovation. Following of that, we need what are the benefits. So what are the benefits you can get? How you get value of IP? So we have three options: cost-based valuation, market-based valuation, and third one is economic-based valuations. These are the three types of valuations you can get it from in intellectual property rights. So what may be the profitable? Actually, we already known well is licensing is profitable. So once I have an invention, I have an idea, I go for patent. That's all. Is it my work is over? Then you can take it is over. But any person want to make it as a product and then they will come and get your permission, means it become profitable. So just keep in mind, an IBM is a company having revenue of patent licensing by around $1.7 billion in 2002. Likewise, every company like Texas, US and Canadian universities, I think all of you know well in foreign US countries, US universities, most of the microbiology or biochemistry researchers are linked with or connected with medical industries or biomedical industries. So whenever they prepare a composition, they apply for patent. So those are went for PDF, they known well. In foreign countries, everybody want to make patent first instead of writing a paper and publishing in a journal. So once they got the patent rights, and then they can go with product making. So once they got success in product making with the good efficiency, and then they will get benefits in millions of dollars every year. So that's why in foreign countries, all the universities are mostly focusing on product-based development, not only simply result-based research. They are expecting product-based research. So that is why they are getting more profit all over the world. Okay, so that's why we say licensing, getting of IPR is more profitable. So this is the one just I want to remind you regarding the concept of IPR. And then regarding of my second topic, just I want to complete within 10 minutes of time. Just I want to give you the glimpses of funding opportunities for extramural research and development. So I think I want to show you what are the funding agencies are available. I think all of you know well, Anusandhan National Research Foundation. Anusandhan means it's one of the initiatives of SERB, Science, Engineering and Research Board. So they have research grants, partnership programs, international program fellowships. Likewise, we have the next option is DST, Department of Science and Technology. They are having individual SERB, Scientific and Engineering Research, Technological Development, S&T, Socio-Economic Programs, International Programs, Fellowships, and Women Scientists. And we have the next one is Department of Biotechnology, DPT. So these are the three major called research foundations funding. So we have three major sectors. One is called ANRF, as of now, ANRF, DBT. Whereas we have other departments and minorities are there. I'll just go one by one. So regarding ANRF or SERB, so we have to just notice what are the types of research grants are available with the conditions. So this core research grant is there, startup research, scientific and useful profound research advancement, SUPRA, and EMEQ, and mathematical research, it is called matrices, and intensification of research in high priority areas, IRPA, and State University for Research Excellence, SURE, and TAR, we are very famous, TAR, Teachers Association for Research Excellence, and finally Fund for Industrial Research and Engagement. So you just see here 50% fund from industry, 50% from the SERB. By means it's a collaborative research, they will focusing on product development. So these are the type of funds available from ANRF, from SERB. And whereas the fellowship programs, we already known well regarding the earliest one is the project works or group projects, whereas we go with fellowships program, again we already know well, NPDF is there, and Inspire faculty, Ramanujam Goswami fellowship is there, Abdul Kalam Tech Innovation National fellowships are there. So all these things, international fellowships like international research experience, Newton Baba international fellowship, international travel support for attending of seminar and conference, and for young scientists, support for conference and seminar. Actually, those are have a chance to organize a seminar and conference. You can apply it with the ANRF. Anasudan National Research Fellowship. So within 90 to 180 days before, so at least 90 days is required to go with processing. So we have to apply within 90 to 180 days, not less than 90 days, definitely going to be considered. So these are from ANRF. And regarding the second major contribution of research purpose is DST, Scientific and Engineering Research. I think all of you know these words: cognitive science research initiatives, clean energy initiatives, innovation and entrepreneurship programs, Inspire Faculty Award and Fellowship, National Geospatial Program, and National Quantum Mission. So these are the different scales DST is funding project. As of now, it's keep on going. Even now it is open. They just have a batch by batch opening up all these processes. And regarding technology and development system, so they have a DS R&D infrastructure, science heritage research initiatives, technology development programs, and water technology initiatives. So these are available from DST, Department of Science and Technology. These are the types of funding opportunities we can get it from DST. And then regarding science for equity, empowerment and development, you just see here. So this is very specific for lower category peoples. So other than FC, we can apply it with specific categories, especially for women also it is possible. So scheme for young scientists and technologists. We have age less than 35, we can get a grant till 40 lakhs for a year of 3 years. So these are from socio-economic development. Other than EWS, you can apply for these cases. And then international and S&T, science and technology programs, you just see, we have an option from DST, it is bilateral. So it is cooperation with, we have an option of 83 countries to be get collaborated. Likewise, instead of bilateral, I can go with the next option of multilateral and regional programs like Brazil, Russia, India, China, South Africa, all these 5 countries. If we have collaborators, we can go for applying a project in this case. And even European Union, I can apply, and Mission Innovation, 23 countries are connected together. So we have difference of options are there in DST International Science and Technology programs. It's very selected, and those are from Women Scientist Program. So especially these are ANRF, Anasudan National Research Foundation. We are promoting opportunities for women in exploratory research. Power, they given the word power, like this translation grant and mobility program. So these are the 3 famous programs available, research schemes available for women in the ANRF. Whereas if you go for DST, we are very famous Women Scientist Scheme. Likewise, Women in Science and Engineering, Societal Challenges for scope, it's for only people other than FC. And then if you go with so much of other programs are also available. Indo-German Women's Program is there. Indo-French Program for Women Science is there. And then regarding of DBT, so regarding R&D program, so these are the sectors where we can have benefits of applying project and get the benefits. So medical biotechnology, agriculture, animal applied sciences, knowledge generation, discovery research, and new tools. So like we just go through it. So we have so much of areas are open to apply with the project on this category. And fellowships also near same as like a CERP. We have different fellowships are available. If you just go through the website, you can get all these details in the DBT website itself. Everything is available. We just go and check with the criteria. That's highly enough. And you have to spend some time to go for your specific. And regarding DST labs, with DBT also we have so much of international collaborations are there, like Partnership for Complementary Targeted Research and the Wellcome Trust, Third World Academy of Sciences, and the Heidelberg graduate programs in big data research. So all these are available. So we can go and search it. And regarding other funding agencies in India, we just noticed we have so much of options regarding Ministry of Agriculture and Farmers Welfare, Department of Atomic Energy, Ministry of Ayurveda, Yoga, Naturopathy, and Chemicals and Fertilizers, Ministry of Coal, Ministry of Defense, Ministry of Earth Science. So just go through it. Ministry of Jal Shakti, latest they have Department of Water Resources, River Regeneration, Ganga Cleaning. So they have a word of Ministry of Jal Shakti. So we have opportunities to apply for a relevant project work. So once they open with the project, we can easily apply for it. So these are the other continual terms, mines, new, actually one of the very famous is Ministry of New and Renewable Energies, MNRE, and then the Ministry of Petroleum and Natural Gas, Ministry of Power, Road and Transport. So everywhere we have so much of agencies are there to provide funding for our required project work. So once you have to choose what type of industry you want to go, you can go and apply. Okay, so this is regarding, sorry, actually I forgot to mention about what are the procedures you have to follow. Sorry. Once again, how to write, actually just I want to make you how to write the project work. Okay. So it is going to be this. Okay, so I think now screen is visible at least somewhat. So regarding writing an effective research proposal, that's my title. Yes, I shown you what are the possible areas you can apply. So what are the agencies available, and then regarding your effective research proposal, what you have to do is very simple. We have these 5 points to be noted. The first one is brief background